As Donald Trump barrels toward making the kind of history we all know he doesn't want to make, being the first American ex-president to ever stand trial criminally. There's some breaking news in the last few minutes on that front. Judge Juan Merchan has just denied a last-ditch delay bid by Trump to derail the hush money trial. It's set to begin in less than 2 weeks. The ex-president tried to claim one of his favorite hat tricks, presidential immunity, regarding important pieces of evidence in this case. Today, the judge saying, quite frankly, it is too late to litigate the immunity claim. Joining us at the table, as she does most days, MSNBC legal correspondent Lisa Rubin.
Hey, Nicole, how are you?
Hey, so tell me what this was about.
So we are now in a universe where we're dealing with some motions that have been filed this week to derail the trial. We've been talking about potentially recusing Judge Merchan, for example. This is a motion that feels like it was filed a lifetime ago, but in actuality was filed on March 7th, just a week after the Supreme Court granted cert, or the review of the presidential immunity decision in the case before Judge Chutkan then. Trump then went to Judge Merchan and said, because the Supreme Court is going to consider whether my presidential immunity argument is valid, you should postpone this trial until the Supreme Court can rule on that. And also, you should hold that the state here, meaning the Manhattan DA's office, should not be able to introduce evidence of my official acts that might be evidence in this trial, including, for example, tweets that I sent that they say were efforts to intimidate witnesses in the case, namely Michael Cohen. The judge deciding today Trump's motion was not timely. He said Trump could have filed a motion either to preclude evidence or to save himself from prosecution on presidential immunity grounds at any time and failed to do so until early March. He denied it on that basis alone, but also said he's declining to consider whether or not evidence writ large should be excluded on the basis that that evidence reflects official acts taken by a former president.
Let me read some of this ruling today. So Judge Merchan writing, as the defendant fails to explain why he waited so long past the statutory period allotted. The defendant had ample notice that the people were in possession of and intended to use the various statements allegedly made by the defendant on social media, in public, and in various interviews. He was also well aware that the defense of presidential immunity, even if unsuccessful, might be available to him. For example, as discussed more fully below, the defendant fully briefed the issue of presidential immunity in his motion to dismiss the matter of the United States versus Trump. That's the Chutkan case. I mean, what seems to be happening, and I want to ask you to take your legal hat off for a nanosecond, is the judge is calling BS on what is not a legal strategy at all, but a political strategy to delay all these trials, because he knows they have a terrible, I mean, he can read a poll. You can say whatever you want about Donald Trump, but he can read a poll, and the Christie campaign and a lot of the other Republican primary campaigns had polling that suggested a criminal conviction was not the boon that Trump will act publicly like it is for his candidacy.
Well, look, I was here with you on the day where the Supreme Court granted cert. That was a very somber day because it represented an opportunity to really delay and derail the one case that many of us thought would be tried before the election. And yet it was an incredible gift to former President Trump, not only in respect of that case, but potentially in others, because he had already moved to dismiss the Georgia indictment on presidential immunity grounds, and we thought that maybe he would try to revive presidential immunity in this case. One of the things that Judge Merchan is seeing here when he says you had ample opportunity to raise that in this case, one of the things he mentions, he doesn't discuss it at great length, is they did actually try to litigate this issue in the case. When Donald Trump was first indicted by the Manhattan DA's office, his first strategy was, let's get this out of state court. I want to bring this to federal court. And in his efforts to remove the case to the Southern District of New York, the federal court here in Manhattan, he said, I have a colorable argument on federal grounds. My colorable argument is that I want to tell you that I'm constitutionally entitled to presidential immunity. That argument failed before a federal judge, Alvin Hellerstein, who said that argument was laughable. So he's known that, at least with respect to this case, that argument's been dead for a long time. Nevertheless, trying to delay the inevitable, as you said.
What are we learning from Judge Merchan through these filings?
I think one of the things we're learning about Judge Merchan is he keeps his docket tidy, right? He's got a lot of different motions that might fell a lesser judge in terms of keeping track of them all, deciding them all before trial begins. This is a person who wants to check all the boxes, right? I have a bunch of motions before me that could potentially throw this trial off track, I'm going to dispense with each and every one of them, and I'm going to do it thoughtfully before April 15th. So what I think we can expect is to see him issue decisions, for example, on recusal, on pretrial publicity, which is another basis on which Trump is trying to delay this trial in the coming days, Nicole, as that April 15th deadline grows closer and closer.
Hey, everyone. MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.